Okay, well, good morning, everybody, and hopefully the daylight savings time is not throwing everybody off. There's a little bit of a lag there, and people are probably a little bit tired from last night. And also, I got to really give it to our guest today, and I know that I got her name wrong. I was calling her Andrea, and really I've understood her name to be Andrea. So we're going to try to correct that as we go along. But the reason why I did is that I actually have a cousin who's married to Andrea, and very specifically, her name is Andrea, not Andrea. So that's where I made the mistake, and I apologize. I always try to get the names right. But yeah, so we're going to be jumping into a lot of stuff today, hopefully. I don't know how long this is going to take. I have some time. I don't know what Andrea's schedule is, but as soon as she has to go, she'll obviously let me know and she'll bounce out. But yeah, there's definitely a lot to get to, a lot to talk to, and I do want to take some questions also. So immediately, I'm not going to be taking questions because we want to cover some ground, and then we'll open it up from some questions and see what we get. Okay, so without any further ado, I would like to thank our guest. We're going to bring her on right now, and here she is. So, Andrea, thank you so much for joining us today on this Sunday morning of daylight savings time. I know it's much earlier there on. Are you in California on the Pacific time zone?
I'm in Washington State, so yes, I am Pacific. I am Pacific Standard Time. I did get up a little bit earlier today, but it's fine. I'm kind of an early bird person anyway.
Okay, well, early the better, early the rise, right? So, yeah, again, appreciate you coming on. I'm going to try, and again, I know I've been telling my audience this, that StreamYard has been giving me a little bit of issues because they're doing some updates, and I want to show some things to everybody while we're talking about it. So, really, I want to first start talking about this order about Crosby, because this is the one that's really been giving me a lot of trouble. It's been giving me a lot of trouble because, you know, as this case has been going on, and I've been following it since January of 2024, I know a lot of people have been coming out, oh, this judge is biased. She's biased. Why don't you just come out and say it? And, you know, her mannerisms and her, you know, while she's talking to the defense counsel and things like that. And I've kind of been like, you know, as an attorney, dealing with a lot of judges and knowing how sometimes judges just get a little upset with one side, or they get tired of their antics, or especially when you're the defense attorney on a case where you're trying to come up with novel, creative arguments to, you know, to protect your client and strike different things and suppress certain things. So like, I understand, like a lot of times I'll find maybe you've also where the judge will be just a little more fed up with the defense side. But what I've kept pointing back to is, look, you know, maybe her mannerisms kind of show one way, but if I'm looking at the actual orders and her rulings in the court, yeah, I don't love the way that she runs the courtroom. I don't like that she's so limited on how you can cross-examine a witness and things like that. But if I look at her orders, you know, I could have found some of the orders going both ways, and sometimes she actually gave it to the defense. So, for example, last trial where she allowed Dr. Marie Russell in the middle of the trial, last-minute notice to come testify, even though she didn't make her go through a quasi, I guess, Daubert Lanigan hearing. But eventually she did allow her in, and I thought, you know, that could have been a very easy call against the defense, and she allowed her to testify. So I've kind of been like, you know, I want to see an order that really shows me that there's just judicial bias here, you know, and I haven't seen it. And then this order comes out, and it's really becoming a lot harder for me to defend my position here that Judge Pannoni is not biased. And you know, as just to kind of set up the question, we know what she made Dr. Russell go through. We know that Dr. Russell, 30 years experience as an ER physician, 30 years almost as a forensic pathologist. She made her go through a 2-day Daubert Lanigan hearing. And then you got this Crosby guy who seems to be a retired police officer who got into some sort of veterinary science degree. And now he's being offered to be an expert about causation, essentially, to these injuries about John O'Keefe. And at the very least, I thought at the very, very least, he should have some sort of Daubert hearing, the same way she made Dr. Russell go through it and test his qualifications, test his methodology. And then she comes out with this order, and she doesn't even call it a close call. So I struggle with any sort of explanation here that doesn't result in her just siding more with the prosecution or being biased a little more with the prosecution. What's your take on this order?
Yeah, you know, if this order were taking place in a vacuum, I wouldn't necessarily have a huge issue with it. Of course, the courts have broad discretion in deciding who gets admitted, who doesn't, what's going to be the appropriate qualifications and so forth. And I think the one thing that we do seem to know about this guy is that he's looked at a lot of dog bites. Okay, I could see how you could potentially translate that into, if you're particularly permissive with expert testimony, how you could translate that into allowing this guy to testify that this particular thing that he's seeing is or is not a dog bite. The problem that I have, though, is, of course, it's not in a vacuum, and it's really the inconsistency of the standard that is so troubling to people. And Dr. Russell's certainly a part of that in how she got treated as well, but also Dr. Rentschler from the first trial, the biomechanical engineer who was there to testify about what could or could not have caused certain injuries to John O'Keefe, and a very specific type of expertise that he has, that even the state's own medical examiner, Dr. Scorty Bello, at one point had testified that, she couldn't opine about the causation of these certain injuries because you would need a biomechanical engineer to do that. And so the fact that the defense wasn't allowed to, they weren't given the same kind of broad lenience when it comes to establishing expertise to opine about the causation of the injuries that the Commonwealth now seems to be getting. That, I think, is what's really catching people's attention. It's not that the decision in and of itself is so outrageous. It's that it's so indicative of how the same rules don't apply to both sides.
Yeah, I think we're seeing that. And then also, the fact that she said herself on the record that only an MD can testify as to causation.
Yes.
So that's even worse when, it's one thing, okay, the case law, and maybe she's not aware of it, or maybe she has a different interpretation of it, but she's come out, said on the record, yes, only an MD can testify as causation. And my experience also in trial has been that only a doctor can testify about causation. I know we always try to squeeze out expert opinions from people that are not qualified. And when it comes to causation of an injury specifically, my experience is that you got to be at least a medical doctor. And from my research, I've seen on this specific issue in Massachusetts, that it's got to be either an MD, specifically when it talks to dog bites, maybe a veterinarian or a forensic odontologist. So I haven't seen anything. And what I've told everybody on my channel is that I think that this is a very strong appealable issue, even if the conviction comes down against Karen Read. Do you agree with that this is a very strong appealable issue, or what do you think about that?
I wouldn't put this as one of the strongest appealable issues. The problem is they have such a wealth to choose from at this point in time. But mainly just because this is going to be a discretionary standard of review, because the judge has so much authority to decide what's admissible evidence in the court, what does and doesn't meet the standards. They have to show an abuse of her discretion to be able to get it overturned. And that basically amounts to a conclusion that no reasonable judge could possibly reach this same decision. It's always a tough standard to meet. So I'm definitely not saying they wouldn't raise it. I think there's plenty of issues like this that not just are they viable, but they add to the cumulative effect of what you can see with these rulings aggregating over the course of the trial, especially when you account for how this is benefiting one side's case over the other. And the counterpoint to that being the way that Karen Read's ability to defend herself. This is a constitutional magnitude, this right that she has. That's being impaired by these same sets of decisions. So while the Commonwealth gets to bring in the dog bite expert, she doesn't get to bring in the mechanical engineer. That to me is where kind of the heart of this issue lies, is the way that it's tilting the playing field in favor of the Commonwealth. So I won't be surprised if this issue comes up in the appeal. I wouldn't probably characterize it myself as one of the strongest ones, just because we're going to talk about some other ones coming up that from the appellate standpoint are very, very strong in terms of the standard of review. So, but it's plenty of room there to argue that it's error and that it's indicative of this biased position that she seems to just not be able to shake.
Yeah, so it seems like like you were talking about, the standard is abuse of discretion when it comes to these matters, and abuse of discretion obviously is a very high standard. We all know that. But yeah, I mean, I think that this could rise to such a level when you're allowing someone who's not qualified to give an opinion about something to the jury, which is a material part of this case. It's not just, an immaterial, it's not like a harmless error type of thing. It's, I think that it's a pretty good part of their appeal, which if this verdict comes down the wrong way. Yeah, go ahead.
Well, and I think one of the things that'll be interesting too, there's actually two things that could unfold over the course of this trial that I think could shed a real light on this particular decision and the effects that it has. One is, does she actually let it go down the road into this full-on pseudoscience of the forensic odontology, right? So forensic odontology, even in humans, is come under serious challenge in recent years. But there doesn't seem to be any kind of validation to be able to use this technique on dogs either. So pseudoscience in the court, it's a hot button issue for me. This is something that I've litigated for years. It's just something that really grates on me because it's supposed to be a truth finding function. And so when you're proffering people that are just kind of making things up that can't be validated, that's just the antithesis of a process that's designed towards getting it right. So question number one is going to be, does she let it go all the way down the road into pseudoscience, where then I think they've got a stronger issue there. But the other issue too is, I would anticipate, based on this ruling, that the defense is going to come back in a motion in limine now, and they're going to ask for Dr. Rentschler to be allowed to testify. They're going to basically point out, whatever you said before, your justification before for not allowing him to testify to causation, you've clearly thrown that out now because you said you had to be a medical doctor. He's not a medical doctor. So we need to go back now and revisit it. Also, that comment that we got from Dr. Scordi-Bello, that was after, she had done the voir dire with the ARCA witnesses and made that determination that she was going to limit Dr. Rentschler's testimony. So maybe, they can bring that in and point that out as well. Look, we have a better record now where even an MD, even the forensic pathologist is saying, I'm not the person who can opine about this type of thing. You need our expert to be able to say that. So I anticipate a motion in limine to revisit the issue of Dr. Rentschler's testimony. If she continues to not let Dr. Rentschler testify, then now I think we've got a really good record of just the inconsistency and the unfairness that is, again, just impeding Karen's ability to present a defense, as it's her constitutional right to do.
Yeah, and it's good. I'm glad that you mentioned that, because a lot of people were sending me messages or questions about, now that this ruling came out, are they going to revisit Dr. Rentschler? I thought also, like you, I didn't just come out and say, yeah, but I did want to discuss that. So yeah, you said very clearly that they are going to file a motion to limine. I would find that also that they should probably file that motion to limine and ask for Dr. Rentschler, just to make, to button up that record really clear about, the inconsistency, shall we say, about the rulings here. So let me just, I know that I didn't discuss with you before this question, but this is something that's just been irking me a little bit. Have you been following the appeal at all in terms of the double jeopardy issue with this case?
Yeah, the habeas. Yeah.
Yeah. So the habeas. So what the question that I really have, and as I've been following this from day one from the appeal, was that if you're arguing that this is a mistrial that was improper, right? That the mistrial did not have manifest necessity, or there was no consent, or the different arguments that they were making. I believed that, according to that argument, all three charges should then be dismissed. And for some reason, which I can't wrap my head around, is that they're limiting it. Their request, at least definitely in the federal level, was only charges 1 and charges 3, and that just left me scratching my head. That I understand if you want to argue the fact that, well, the jury really came to a verdict on charge 1 and charge 3, and that's why we're asking for double jeopardy. Okay, I get that argument. But when you change the argument to the mistrial was improper, well, then that mistrial was on all 3 charges. There was no manifest necessity for all 3 charges, because she didn't give counsel full opportunity to be heard. It didn't carefully consider alternatives. That should apply to all 3 charges.
Yeah.
So
I think you're absolutely right. I think this is a great insight that you had. And yes, that would be the remedy, because the problem is the mistrial affects the entire case. It doesn't just affect the charges that the jury ostensibly acquitted on. And so, I mean, from the federal standpoint, the reason why they didn't raise it in the federal court is because they didn't raise it in the trial in the state court. So they didn't exhaust that request through the state court, and it's not something that's going to meet the standards to be able to request relief for in habeas. But it does, raise the question then of why didn't they make that argument in the state court? Was this an oversight? Was this a strategic decision that sometimes you don't want to get out too far ahead of your skis. You don't want to ask for too much and potentially damage your credibility. Certainly the two charges on which we have a record, from multiple jurors that they did in fact acquit her on, those are the most sympathetic ones, certainly to be able to ask for relief on. So I think you're absolutely right that the manifest necessity for the mistrial is the type of error that should affect all three charges. Why they didn't raise that, I don't know. I really don't.
Yeah, and her appellate attorney is supposed to be a very, very well-renowned Marty Weinberg, and he's supposed to be very experienced. And it was just a question that I had going through this entire appeal process. But what's your general take on the appeal? Do you think it's going to be successful? You think it's a long shot? What's your take on that?
Yeah, it's definitely a long shot. So I looked at it very in depth when it was at the state level, and it was quite crystal clear that the state law was not going to be in her favor. It was not a hard call for me to predict. She's not going to win this argument. When it got up to the federal level, she's still in a bad position when it comes to the actual double jeopardy and the use of the juror testimony. Testimony about what happens in the deliberation rooms, kind of one of those sacrosanct rules. You just don't get it. You don't get to do that. You don't get to go in and criticize the way that they reach their decision and so forth. But that issue of the manifest necessity, when I started looking through that and through their federal briefing, it does actually look quite a bit stronger on the federal level than it does at the state level. They had some very good, very persuasive case law dealing with situations where the court got reversed because it didn't explore remedies that the reviewing court felt would be available under the circumstances, even in situations where the court seemed even more constrained than Judge Cannoni was in this particular case. So the fact that they have that argument, that not only, I think one of the very strong arguments that they had was that the statute itself allows them, after the Tui Rodriguez instruction is given and the jury still can't reach a verdict, the jury can still continue to deliberate with their consent. If they choose to do that, they can do that. So asking them to continue would have potentially been an option. But also, of course, as the defense is pointing out, polling the jury would have been an option. It's available. No, it's not mandated. Although they do seem in their argument to be trying to encourage the court to make that more of a rule, make it something that the court should do under the circumstances. So it's a situation where I do think they're on better footing in the Court of Appeals, but ultimately, federal court, yeah. Ultimately, if I were Vegas trying to set odds on this one, Karen is still the underdog. She's not likely to win this one. She's just maybe in a little bit of a better position in this venue than she was in the state courts.
Yeah, and that's exactly my analysis. That's pretty spot on to exactly what I said about the federal level, that I think that she has a better shot in federal level, but still I think, like you said, it's a long shot to get this to get it reversed. Yeah, the partial verdicts, the fact that there was no careful consideration for the alternatives, there really wasn't. And this whole novel argument that the Supreme Court came up with their decision that, well, by asking them, you're essentially requiring them to go through further deliberations, which is not allowed after you ask the Tui Rodriguez, after you give the Tui Rodriguez charge. I thought that was just a faulty analysis by the Supreme Judicial Court. I thought that they had a much easier way to go about it, and that is that, from what I've seen in Massachusetts case law and the state cases, is that if their failure to object can mean that they've consented, and even though if there's a very limited amount of time, the only cases that I found where they were not required to object is when it was completely out of the blue, where the judge just walked into the courtroom, essentially, issued the mistrial, or if there was a case where there was an attorney who was like his first case, and the judge was berating him to his face and saying how he messed up so badly. And then she said, I'm going to issue a mistrial. And what do you expect the guy to do? To stand up and say, I object? So like, those are the only situations where I found which I found it would have been a much easier analysis. And in fact, one of the footnotes in the Supreme Judicial Court opinion was that we're not even going to talk about that prong because they analyzed it all under manifest necessity. So I thought they could have gone completely the opposite. They could have said, we're just going to analyze this under the objection standard, and therefore there equals consent. And we don't have to get into manifest necessity because, like what I said, when you get into the manifest necessity, you're going to have a lot of more problems with the fact that it's very clear that there was no record about, carefully considering other alternatives and giving counsel full opportunity to be heard. But that, that's what they've done. And nothing surprises me, at least at to find interesting things and opinions. Let's move on to, before we take questions, let's move on to the Bettero issue, because this is, I think, also came out on Friday. The order came out on Friday. Now, just to kind of set the stage about what happened here is that initially, Yannetti filed this affidavit, and in the affidavit, he very bare bones kind of laid out why Bettero should be admitted pro hoc vice, and Judge Cannoni said, you gotta buff up your affidavit a little bit, and then I'll most likely make a ruling on the papers. Then he filed this much more of an extensive affidavit. I just saw this on Friday also, I think right before the opinion came out, or the order. And in that affidavit, he lays out specifically, why Bettero should be allowed to be admitted into practice for pro hoc vice. And I looked through some of the rules that I think is necessary. But if you don't mind, let me see if I can pull this up. I'm going to ask somebody in the chat to let me know if you can actually see what's going on here on the screen, because sometimes I have issues with StreamYard. So just somebody on the chat, just let me know if you can actually see what we're looking at right now. Do you see it, Andrea?
I see it, yes.
Okay, great. So it looks like the people in the chat also see it. So I just want to point something that caught my attention, right? So this is the order where she says, after review of the pleadings of defendant's supplemental motion for admission pro hoc vice of attorney Mark Bettero was denied, and this is what her reasons are. The affirmation submitted in support of the motion, I don't know why affirmation's in quotations, like it was a real affidavit, so I'm not exactly sure why it's in quotations, but okay. The affirmation submitted in support of the motion is insufficient on its face, period. And then in addition, she gets onto the rules of professional conduct. And the affirmation submitted in support of what is insufficient on its face, no explanation there. Why is it insufficient on its face? It was an extensive affidavit going through all of his qualifications, all of his experience, going through everything. I didn't understand that. If you want to say not in addition, but because of the next part that she's going to say, okay, maybe, we can discuss that. We'll discuss that in a minute. But when I looked through that affidavit, did you notice anything that's just on its face insufficient?
No, I didn't see anything that was on its face insufficient. And in fact, I was going to see if I could pull up. I went and looked at what the Massachusetts rules are for pro hoc vice admission. What's the process to be able to do that? And I
see we both do our homework.
Yeah, it's a fairly standard set of requirements that it's common in most jurisdictions, where you just have to lay out, that you're more or less like that you're in good standing in a particular jurisdiction. You have your experience. You want to come on. The person wants you to come on, and you're going to be subject to the oversight of whoever local counsel is. So, on its face, the rule doesn't require a particularly extensive showing. You certainly don't have to justify why the client wants you in, or why you should be allowed to appear in the case. You just pretty much have to show that you meet some basic qualifications and you're not a problem lawyer. So I have no idea what this conclusion is, that the motion is insufficient on its face, because she's not telling us.
All right, she doesn't tell us, and from my research and your research, it seems like everything was completely fine about the affidavit. He's in good standing, goes through his qualifications, and yeah, I mean, that was a little bit, again, I'm looking at these orders a bit more careful now, but I didn't understand that part. But then she gets into the next part, which is, I guess, what people are also trying to wrap their heads around. So then she says, in addition, the proposed concurrent representation involves a conflict of interest that is not waivable under Massachusetts Rules of Professional Responsibility. See Massachusetts Rule of Professional Responsibility 1.7a and b. See also comments 22 and 23. Now, I looked at those last night in preparation. I'm not sure if you were able to take a look at that.
I did indeed.
You what?
I did indeed.
Oh, you did indeed. Okay, great. So we both do our homework, which is good. I think that's why people like enjoy watching us. So I looked at those. Essentially, those are the rules of professional conduct that govern conflict of interest, which everybody understands. Conflict of interest, it's a big consideration that you have to take before you represent another client. You always have to do a conflict search. Make sure that you're not conflicted out, and if there is, and you get a waiver. So I looked through these comments. I looked through rules of professional responsibility 1.7 A and B. I understand, for example, when you have co-defendants. So for example, for some of my audience is familiar with the Donna Adelson situation. So you had in that situation, you had this guy Dan Rashbaum who was representing Charlie Adelson throughout the first trial. He's been convicted now, and now Donna Adelson was her trial's coming up, and literally like a day before the trial, there was a motion filed because they were intending on calling Charlie Adelson as part of their case in chief. I think it was a category A witness, and or even if they're going to potentially call him on rebuttal. Either way, the point is that if you got Charlie Adelson taking the stand, who was represented by Dan Rashbaum, and then you've got Dan Rashbaum also representing Donna Adelson, who are really in this case co-defendants. Then having that and officially on the record, he said that they did get waivers, and that was okay with the judge. Initially, that was okay with the judge, and he would go through this with the Judge Everett, who is extremely well versed. I found all of his opinions very solid, and the legal analysis really solid. I haven't really had many issues with any of his opinions so far, and I've been following that case carefully also. And he was completely okay with that, even though, despite the fact that they're co-defendants. Now, I know that in the comments of 22 and 23 in the Massachusetts Rules of Professional Responsibility, it says you should be very careful. We don't love that one person is going to represent co-defendants. It is possible from the case law that I've seen, depending exactly what the defenses are going to be. But he was completely okay with them as long as they have a waiver. And then once it became an issue of calling the person as a witness, then it became an issue because their interests may conflict or contradict each other. So then did that become a non-waivable conflict? In this situation where you have Mark Betterow, who's been representing Turtle Boy, as we all know, and now it's with respect to the witness intimidation charges, right? So you got him representing Turtle Boy, and now he wants to represent Karen Reed. Now they went through the affidavit. They said that they were each able to talk to independent counsel about this, get advice from independent counsel about this. They signed the appropriate waivers. They all were completely familiar with the potential conflicts and that they're waiving it and yada. They did everything like cross their T's, dotted their I's, it seems like. So do you see what she's talking about here, that this is a non-waivable conflict?
No, and in fact, I think the rule in what she's actually citing to, it tends to directly contradict what she's saying. The rule is the rule 1.7 is pretty clear. It's got these two parts. The first part says here are the circumstances where you can't represent a client involving a concurrent conflict of interest, meaning they right now, as we sit here right now, they have opposing positions. They have interests that are not in alignment. And so the one that she's relying on is there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person or a personal interest of the lawyer. So what she's really highlighting here is, look, he's representing Turtle Boy. He wants to represent Karen Reed. One way or another, he is going to have to limit the work that he does, the advocacy that he's able to give for one side or the other, just because of, I guess, the nature of the relationship between them is kind of what she's saying. But then you go into this subsection B, and it lays out very clearly when that circumstance can be waived. And so even if you have this concurrent conflict of interest, subsection B says the lawyer can represent the client if, number one, the lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. That was in the affidavit, that is Mark Betterow's position. He can fully and fairly represent both of them. The representation is not prohibited by law. It's not. The representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal. So they are not directly adverse parties to each other. You can't, it's like the one very crystal clear, non-waivable conflict situation. You can't represent the people that are at the opposite sides of the table. They need to have separate lawyers in the process. And number 4, each client gives informed consent confirmed in writing. And we had the, as you pointed out, very detailed affidavit that was laying out exactly how he disclosed the conflicts, discussed it. They had independent attorneys. Everybody is okay with this. So on its face, I don't see that it meets the requirements of the rule. But it's so difficult to understand what Judge Bev is even thinking, because once again, she doesn't give us her reasoning. We don't actually have a record here of what, according to her, the potential conflict is. Because when I look at the situation, I see, okay, we know that the Commonwealth wants to get into the Turtle Boy stuff. We're gonna, be talking about that motion pretty shortly. So maybe there's a possibility that Turtle Boy gets called as a witness in the retrial. Well, his interests and Karen's interests are, as far as I can tell, in alignment, because they're both taking the position, this isn't witness intimidation. That's not what we were trying to do. Trying to get publicity on your innocence is not the same thing as trying to, conspire to commit some sort of criminal act, which both of them deny, and apparently a grand jury also rejected, declined to return any indictments on that type of allegation. So, I mean, is it possible that there's some kind of conflict here? Maybe, but we don't have a record of what on earth that is and what Judge Cannoni here is thinking. So I don't see at all how this reasoning is following from the situation. And for that reason, I think this order is likely to be a major overstep on her part. And it's the type of ruling that does have the potential to be an extremely strong issue on appeal.
Yeah, because this is not reviewed for an abuse of discretion, right? This is
well. So the way that this
fundamental right under the Constitution to have your counsel of choice, right? I mean,
so it is, but there is some overlap between those. So it is an abuse of discretion standard when they're looking at, has she correctly applied the Massachusetts Rule of Professional Responsibility 1.7? But that's where, because she's actually given us some legal reasoning here, Judge Cannoni often doesn't give us legal reasoning. This is something I've pointed out before with this practice about how the parties aren't allowed to state their objections in court. And it's my opinion that the reason she does that, which is a very, very odd practice, very unusual. Don't know if you've ever seen that in any court you've ever been in. I have not. It's just part of basic advocacy that if you're going to object, you need to advise the court. You need to go on record of what your basis is. But so my theory about why Judge Cannoni doesn't do that is because then it allows her to make the decision kind of on the fly. And when it goes up on appeal, there's a general rule in appellate practice that the trial court, they can be affirmed on any basis that would be supported by the record. And so if she makes a ruling based on a specific rationale, it's much easier for the appellant to go in and challenge that rationale, say, you're legally wrong. And being legally wrong is one of the ways to establish an abuse of discretion. You didn't understand the standard correctly, then you necessarily didn't apply it correctly. But if you don't give a reason, then the court can potentially just look at, well, is there any reason that would justify this ruling? So it's a way of really keeping the door open for any potential justification for why that objection would be sustained or overruled to be able to validate it in a review process. So she has made the mistake here of identifying what her legal reasoning is. And because of that, they're going to be able to challenge it. And they're going to be able to go in and point out, look, here's what the rules actually say. And here's how they say this is a waivable conflict. And look at the affidavit. And the affidavit says they met all of these requirements that the rule would require them to do. So she doesn't have a factual basis here of something that would take it outside of the purview of those rules that seem to pretty clearly indicate they can address this issue and they can choose to waive it. So they have a good argument that she's abused her discretion in interpreting this rule of professional responsibility. Then we get to the U.S. Supreme Court case of Gonzalez-Lopez. This is a case that Mr. Alessi, when we were having that hearing on the alleged misstatements by Mr. Jackson and the candor to the tribunal issues and so forth, Mr. Alessi kept hammering on this case. He was like doing everything in his power to try to get Judge Cannoni to read this case. And there's a very clear reason why. This is an extremely strong case for the defense. This is a case out of the U.S. Supreme Court that deals with your right to counsel of choice under the Sixth Amendment. And what that case establishes is that if a trial court abuses its discretion in ruling on a pro hac vice admission question, that constitutes a deprivation of the right to counsel. And the deprivation of a right to counsel of choice, this is the holy grail of legal errors on appeal because it is a structural error. It causes automatic reversal of the case. You don't have to go in and show that the attorney would have contributed something, that there would have been some different outcome, nothing like that, like you have to do in the ineffective assistance of counsel context. So structural errors are extremely rare, and when they land in your lap, they are just an absolute gift. And that's what the defense has here. So because of that, a lot of people have asked, what are they going to do? They should run and they should appeal this immediately. Absolutely not. They're not going to do that. They are going to leave this in their back pocket because it essentially puts them in a pretty good position to potentially just have a free shot at acquittal at this trial. And when and if Karen Read got convicted and they needed to be in an appellate situation, now they can play this card and pull it out. Well, she didn't get to go through this trial with her counsel of choice because of this decision that Judge Cannoni made that can't on its face be justified by the rule of professional responsibility that she used to justify it.
Yeah, and that's why I said, I think that Karen Read can have some comfort going into this trial now, because I think everyone's realizing Hank Brennan's going to be a little bit different than Lally. Things a little more tough, and we'll see. The decision on the ARC experts is still open, which we'll get to probably soon. But she can have some comfort going into this trial, knowing this is a free shot. Again, it's not a free shot because if she gets convicted, she's going to be sitting in jail while that appeal is happening.
Sure.
But yeah, I mean, I agree with you that they should not take this up on appeal just yet because they should have it in their back pocket. In terms of what you're talking about, the fact that she does not allow you to state your basis of objections, I haven't seen that. I have seen. I think that what she may be confusing is that I know the judges don't like talking objections; they don't like speaking objections. So, when you're kind of coaching the witness that way or arguing your case to the jury while you're making an objection, that time. I've gotten reprimanded by judges plenty of times because you're trying to do the best for your client, and then you'll make some sort of objection, saying objection, he can't possibly know that, he wasn't even near that at that time, and you go start going on and on with your arguments, and the judge say, hey, you're gonna have to state your basis for the objection, but not to state any sort of a basis of objection. So to kind of get back to your point is that that leaves open any justification at all. But you know what else it leaves open in my view? It also leaves open in my view any sort of reason for your objection. You can then argue to the Court of Appeals, no, that wasn't just a hearsay objection. That was a foundation objection. That was an authenticity objection. That was a mischaracterization. You can argue all the reasons for your objection also, I think, and you can argue that you didn't get a chance to explain your objection. Now, something that, in direct contrast to what happened in this case, I followed the Michelle Troconis case. Did you follow that also?
I did not follow that one, no.
Oh, okay. So just to give you a little bit of an idea, like that judge was just phenomenal to watch. I mean, for anyone who wants to see how you're supposed to rule on objections, every objection had to be there was the basis to an objection. The judge would analyze the basis, and he knew the rules like that. He knew the case law like that, and he would analyze it on the record, which is so educational and so refreshing to see. It just gives a lot more less speculation for us to figure out what the objection was, what's the basis, and what's the reason for the ruling. He laid everything out, and then you can analyze it and say, look, either I agree with it or I don't agree with it. But it was a very clear record what the objections were and what the reasons for the objections were and what the reasons for the eventual rulings were. I want to get on a little bit more to this order, which she moves on to explain that there is an inference. Let's pull it back up here for a minute, just to go a little bit beyond what I highlighted. The clear inference of the promise is that Mr. Betterow would not use protected information gained in the representation of one client for purposes of his representation of the other client. He thus proposes to ignore information known to him through his representation of one client, even where the information might benefit his second client. The court cannot permit such conflicted representation and declines to add to the defense team that currently number at least 4 lawyers, which may also be a little indication of what she's planning to do with Alan Jackson, but we'll get to that in a minute. 3 by mission Parag Viche. So here's my question. Again, kind of what you said. There's no record, not even in camera, to talk about what sort of protected information there is that Mark Betterow may have learned or gleaned from his representation in Turtle Boy that he may not be able to use in the Karen Reed case that can negatively affect her. So, there's a lot of protected information that you can have about one client that really has nothing to do with another client that may have a conflict with that other client. So, for example, if you represent an insurance company and you happen to know, how much revenue they made last year, that's protected information. You're not allowed to share that with a different client. But if that piece of information is not going to directly or adversely affect your representation of this other client, well, then, why should that be an issue? So here we have, again, where it's a very nice idea, statement. Oh, you may have some really juicy, great information that can really help Karen Reed, but you're not able to say that because of your representation of Turtle Boy and their protective order, whatever it is. But we don't even know what that is to even, so why not have an in-camera a hearing on this and see exactly what's protected and what can potentially come out in the Karen Reed case. And it's just completely absent. Exactly what I think what you were talking about, right?
Yeah. And part of the irony in this too is because we have this now pending motion that the Commonwealth's bringing that I'm sure we'll talk about as well, the motion to kind of import the Turtle Boy discovery from his independent witness intimidation case that he's facing into a Karen Reed's case. And what we know about that discovery, as far as, some of the content of it is it's, essentially their phone communications. And so he wants to bring in the phone communications into Karen Reed's case. So if that happens, number one, it doesn't seem like it's any longer protected information, right? If the whole issue is that there's sealed discovery in Turtle Boy's case, and he would be inclined to use that for the benefit of Karen Reed, well, by importing it over into this case, if that were to happen, then it's no longer sealed, and she'd be able to use it as well. You're not going to have a ruling where only the Commonwealth gets to use this discovery and the defense can't. That would clearly be a problem. So if it came in, it would be relevant. They would be able to use it. It would be equally available to both of them. So I'm having a very hard time of trying to extrapolate from this reasoning what exactly is the problem that she thinks there could be, because she doesn't spell it out to us. And like you said, she hasn't done anything to try to develop what the actual situation is and why that in her mind potentially poses a problem.
Yeah, and exactly. And just to bring back the Adelson case, when this whole issue happened with the conflict, there was an in-camera hearing with the judge and the attorneys. He developed it. He was very clear about, that, and we don't know what it was, but they had this sort of in-camera hearing where they were talking about this conflict to see whether it's going to be an issue or not. And that's probably what should have been happening in this case as well. Let me just kind of segue into something else before we get into that motion for the Turtle Boy stuff. And that is that other part of this order, which I just read for you, which says that the court cannot permit such conflicted representation and declines to add to the defense team that currently numbers at least 4 lawyers, 3 by mission pro hoc vice. Now, everyone's kind of waiting on this, what she's going to do with Alan Jackson. As you know, those representations at sidebar and maybe in some of the filings about the relationship between them and ARCA. So she's sitting on this. Everyone's waiting for this order to come out. Trial is coming up really soon. She doesn't want to adjourn the trial. And to me, if she's going to, at the 11th hour, say, you know what, Alan Jackson, I've come to my decision. I've looked at all the case law. I've looked at everything and the rules of professional responsibility and 3.2, yada, yada, yada. And therefore, you're off the case. Well, wouldn't your first move be as a defense team to move for an adjournment that the lead counsel of the case now got thrown off the case at the 11th hour? And if the last thing that Judge Cannoni wants to do is to adjourn this trial, well, then, does that mean, are we reading in the tea leaves that saying that she's not going to throw Alan Jackson off the case? What do you think about that?
Yeah, I mean, I feel like that's been kind of a reasonable assumption from the outset. Part of it, of course, because of this, what seems to be a personal interest that she has in getting this trial started on April 1st, come hell or high water. No matter what, we're going to start then. And clearly, getting rid of the lead defense attorney is it's an absolutely valid justification for the defense to say, well, you know what, then we're going to need more time to be able to prepare because we have to reformulate our defense strategy. We have to reallocate what the responsibilities have been. Whoever is taking over for the portion of the trial that Mr. Jackson had prepared for, they're going to now have to go in and prepare for that. And so expecting that to happen in a matter of weeks before the trial gets started, it simply is not realistic given the scope, the magnitude of this case, the volume of evidence, the fact that there's an entire trial, before that, that is potentially, testimony that's available as evidence, prior inconsistent statements, all of that type of issue. It would take an enormous amount of time to get up to speed and to be prepared to go forward. So the defense would have the ability to make a very strong record for why the April 1st hearing just absolutely would not be viable to start at that point in time. But of course, once again, we've got this issue with the choice of counsel, right? This is strong. It's a strong issue. It's a risky issue for the judge to be making rulings on. Now, seems like maybe she's not all that up to speed on exactly what a significant ruling kicking out somebody's private attorney would be from a Sixth Amendment standpoint. But at least in theory, that's normally going to cause a judge to be a little bit hesitant about following adopting a remedy that's that extreme. But the other part of all this too is just, is there something else? Is there some other adequate remedy that if you think Mr. Jackson did something wrong, that you can address that with a less severe sanction? And generally, if you're talking about competing rights, the right of somebody's choice to their own attorney, the right and responsibility of the court to maintain its rules and its decorum and ethics and so forth, you typically want to find the balance that isn't overkill, that's going to adequately accommodate both of these competing interests. And so if there's an issue with candor to the tribunal, is there a way that she can address that falls short of full on removing him from the case? And I think this order in and of itself doesn't necessarily clue us into that, but the ruling that she gave us on the gag order, another situation where Mr. Jackson is alleged to have engaged in improprieties, to have done things that are contrary to the at least expectations, if not rules and orders of the court. Removal is not something that she's considering as an option for that. So she does seem to recognize that a less severe sanction is typically going to be required under the law, and it's appropriate under the circumstances. And that to me makes it extremely unlikely that she would remove Alan Jackson from the case.
Yeah, and just also another thing that she mentioned, I think it was that last hearing or two hearings ago, where she said something to the effect of, when one attorney signs on the papers, because I pointed this out to my trial where we were starting to see how each attorney started taking responsibility for what they specifically did. So like Elizabeth Little filed this, statement of clarification saying, I wrote this motion. I want to clarify what I wrote, you're finding a little bit more about that. And you're also finding Judge Cannone being much more careful about, what each person is saying, as we saw from the last hearing, when this first thing that you started asking Alan Jackson is about, you file this and you file an affidavit that this is all in good faith about fanning and all the jury stuff. And so she was really pointing, again, and in the back of my mind, probably the back of her mind is, she's still trying to button up this whole misrepresentation issue. Is this another issue? Is this something that I'm going to have to also consider? But something that she said in that hearing, which I took a little bit of issue with, is that when she said that when one attorney signs, you sign for the entire firm. And I understand that part. And therefore she was kind of suggesting that if a misrepresentation is made by one attorney, well, then all attorneys kind of can be thrown off. To me, I guess she didn't say this, but it seems like she was suggesting that you all kind of take responsibility for every single one of your statements. And therefore, if I find, she didn't say this, but this is what I understood from it. If I find that one of you should be thrown off the case because of your lack of candor to the tribunal, well, then all of you have to go. And Alessi got up and he said, Your Honor, I would agree with you when it comes to Rule 14 or other discovery violations, but now when it comes to rules of professional responsibility, that goes against the mens rea of knowingly, that each attorney has to knowingly make a false representation to the court and not correct it. So that actually has to do with what each individual attorney knows subjectively. And I have to say that I completely agree with him with respect to the rules of professional responsibility. But her point about when one person signs, you sign for the firm. Yeah, that's in terms of the legal arguments, in terms of the good faith for, the factual the basis and things like that. Would you agree with that also with my analysis?
100%. I mean, if you're, it's just one of these black letter rules. If you're going to try to find an attorney in contempt, contempt is a knowing and willful violation of a court order or a statute or something like that. And we had this come up over in the Delphi case, in Richard Allen's case. I don't know if you were able to follow any of that. It was a little bit tricky to try to follow it because of the transparency problems that we had. But at one point,
you were in the courtroom, right? You were actually.
I was in the courtroom for that one, yes. But this issue I'm talking about, it was pre-trial. What had happened is she had removed the defense team because there had been a violation she alleged a violation of the protective order governing the discovery, because one of the attorneys had somebody who basically had access to the discovery, but didn't have permission to be able to use it. It's like former employee of the firm got into the room where they were keeping it, took a bunch of photographs of it, and then was disseminating those to various podcasters and media folks. So
not to you.
No, not to me, not to me. And so the judge, I mean, I think naturally is outraged by this. Nobody wants crime scenes of, brutal murders of young girls out there floating around in the public. So this protective order was in place for a reason. At the same time, it's clearly a situation where this was not the attorneys themselves that did it. The attorneys themselves, Mr. Baldwin, whose office this took place in, he's a victim of potentially a crime. I mean, the gentleman who was involved in this was charged criminally for his actions in it. The other attorney, Mr. Rosie, this isn't his office. He doesn't really have anything to do with it at all, or with how discovery is being handled and so forth. So these attorneys had been removed from the case. They fought it all the way up to the Indiana Supreme Court. The Indiana Supreme Court agreed with them, reinstated them. And then upon being reinstated, the prosecuting attorney then proceeded to try to charge them with contempt. And they had a whole separate proceeding where they had to defend themselves against these contempt charges. And that same issue is really what the whole issue turned on is was there a knowing, an intentional, willful violation of the court's discovery order? And even the court, who, I mean, boy, you want to talk about bias against the defense. I mean, Judge Gohl really took it to a level that's it's not a competition, but an entirely different level than what we're seeing here in Massachusetts. Even Judge Gohl had to acknowledge you
maybe some people will find comfort in that.
Yeah. Trust me, it can be far, far worse. Even she could not, justify a finding that there was willful misconduct under these circumstances. So she took the opportunity to really smear the lawyers in her ruling and say very nasty things about how negligent and sloppy they were, and how concerned she is about ineffective assistance and all this stuff like that. That's entirely inappropriate. But at the end of the day, she has to find I can't find them in contempt here. There's no basis for it. So I think Mr. Alessi's point is extremely well taken, because a contempt, it's based on something that the attorney is deliberately doing to flout the court. And so you can't attribute the conduct of somebody else to a lawyer in the contempt setting the way you might be able to do when it comes to should there be a sanction for discovery or something like that just encourages the attorneys to be a little bit more careful, a little bit more cautious, maybe to verify with each other what the facts are before they go and sign their pleadings and submit them into court.
Yeah, and I covered that specific issue. I didn't cover much on the Delphi case, but this specific order, because it was so it was so interesting, and it was implicated the Sixth Amendment, and it was like a crazy, situation. So, yeah, I mean, unfortunately, the lack of transparency and no cameras and no video, so we had to kind of rely on you and other people that were in the court. And I always have my doubts about what type of information I'm getting if I'm not actually to be able to see it. So we kind of had to
100%.
take your word for it. So I didn't cover it much, but I did cover this specific issue. And this is kind of where the judge came out on the record and basically told them, like, I guess in camera, that either you withdraw or you're going to go through public humiliation, like that type of thing. So yeah, I mean, it was a crazy issue. And I was like, yeah, I would not want to be in front of that judge. I think they moved to recuse that judge, didn't they? And then
they did.
And then the judge stayed on the case. So yeah, that would not be a pleasant experience to try that case in front of the judge who found that you were so incompetent that she had to throw you off the case. I mean, yeah, talk about trying to fight that battle going uphill. Before we move on, I do want to get to some super chats and some questions. So let me just pull them up here. Haley Wolf, thanks for putting the show together. You both make things easy to understand, which I think is both of our reasons why we do this. Here we got from Bobby Alessi's Linguistic. From a legal perspective, I'm curious what both of your thoughts are regarding what types of motions we might see filed tomorrow in relation to any of all this. So I think you kind of covered some of that, Andrea, about the motions in limine that we're going to probably see with Dr. Rentschler. I know that I think they have to March 17th, 18th to file their motions in limine. So we'll probably see some of that in respect to these orders. Betero, like you said, just probably nothing's going to happen with that. They're just going to let that kind of sit and then bring it up on appeal if this goes the wrong way. But yeah, I think we discussed a lot of that. 5 Brother Council memberships by Melissa Dotson. Thank you very much for that. We have Kim Neighbor. Andrea, I'm grateful Karen's trial is exposing potential for corruption in our system. I also believe the situation needs a Matthew McConaughey, a time to kill moment. We should close our eyes and imagine for a minute that Karen Reed is black.
I think, it's a fair point. Because we do have this certainly it's the objective and it's the ideal of the system that it's even-handed and it's colorblind and the laws are equally applied to everybody. But the practical reality of that is just not how things work. And not necessarily because anybody is deliberately trying to be unfair, but there's just it's a complex system. There's all these opportunities for decisions to accumulate, and at certain points, study after study of the criminal justice system shows that when there's an opportunity for discretion, it tends to operate to the disadvantage of some people relative to others. It would be, I think, so obvious if we were looking at this situation and Karen Reed was an African-American man. It would be so obvious for us to look at this and spot that this seems to be unfair and it seems to be obvious. And in fact, they might not even dare do it because it would be so apparent. But because she's wealthy, different types of rules apply. She's an attractive woman. Different kinds of sets of rules apply, and different kind of sets of biases that people have play into their perception of her and their perception of the system and how she's treated by it, how she should expected to be treated by it, and so forth. So I think the socioeconomic implications of this case, they really are interesting to me. So I very much appreciate that comment and the sort of thought process that it generates for me.
Do you feel, and this is something that I've thought about and discussed, do you feel that if this wouldn't have the publicity that it does, and the federal investigation that was open, if this was in a quiet town somewhere that no one's ever heard of, and then you get all these issues on the case, do you think the prosecution would just quietly make a real nice deal with the defense and just, slap on the wrist or something and not be so crazy about trying this case again? And despite whatever happens, we are going to do it. I think a lot of that is because they want to save face to the public, and everyone's hearing about corruption and conspiracy and rulings like this, and how it's not fair, and they want a conviction so badly, kind of to save face, that's why they're taking that type of stance and posture. Do you feel like if this is in a quiet town, this kind of just goes away and nobody sees trial in this case.
Oh, I think that's very possible. It's fascinating to me to think about just the different decision points where this case could have gone a completely different direction had Karen Read been somebody else. Had she not had the resources that she has she not had the will to fight, if she had maybe not as clean a background. Sometimes one of the problems in the criminal justice system is that people get trapped in it, and just because you've done bad things in the past doesn't mean that you did the thing that you're accused of in this particular action. So I can see so many points where, even just looking at, for example, the kind of comparative case of Sandra Birchmore. Sandra Birchmore wasn't wealthy, wasn't in the same kind of position as Karen Read. And how long did it take to get any type of attention on her case, to get any type of action on her case? Once again, it took the federal government intervening because the Norfolk County District Attorney's Office and the Canton Police Department and the Stoughton Police, they're not interested in pursuing any of this. So would there even have been a federal investigation into Karen Read's situation if she was not Karen Read, and if she wasn't in the position to be able to raise the profile of what she is alleging happened to her? The reality is, I think if she was a poor, underprivileged type of defendant, maybe has some priors or something like that, the deck is already so stacked against you. We're probably not even having the first trial. You're having somebody that doesn't have the war chest that she has to be able to hire top-notch attorneys, to be able to hire reams of experts to come out and support her case. So the whole picture of what would happen at trial is a completely different picture. Yeah, who you are in the justice system shouldn't matter, but this is just such a great example of where we can look at the ways where who she is has made a difference in this case.
And you think about what materials they were provided because of the federal investigation. Those text messages of Proctor were only turned over because of the federal investigation, right? Yes. The ARCA experts were provided because of the federal government. Those were expensive experts, as we all just saw, $23,000. Mm-hmm. Now everybody has that type of money to spend on these experts, and to get those text messages from Proctor, which really caused the jury, which one of the jurors who spoke out said that once they heard those text messages, they were basically, okay, this guy lost all credibility. And this is the lead investigator of the case. So, those are the things we don't know in all these cases, all these other cases. We don't know how the police are talking about these cases with their friends. We don't know if they're using tunnel vision. We don't know if the Boston cop is not going to catch anything on this because he's a Boston cop. We don't get to see all that in a lot of other cases, which is why people are looking at this case and saying, who knows how many other cases like this where we don't know all this information and people are sitting in prison because of it, or they didn't have good representation because of it, or they weren't able to put on a good defense because of it. So these are real considerations that this trial is bringing up to everyone's mind, and it's something that we should really, as a society, carefully think about, and maybe it should make some changes going forward with criminal defense. Let me move on a little bit here. We got Calico 26. What if something happened to Bev, like a heart attack? What would happen in this case? Obviously, we don't wish harm on anybody in this case. But if for whatever reason Judge Cannoni would not be able to preside over this case, then they just have another judge. It'd have transferred to another judge, right? Mm-hmm. Yeah. Okay, let's move on here. We got Marie Martins. Hi, you both are amazing. How is Turtle Boy stuff be allowed in when Karen wasn't even charged? This is a murder trial, and bringing actions of others seems evil to me. Thank you. So the reason that I've seen which we're going to get to soon, I'd like to get this motion, is that they're going to make an argument that there's some sort of consciousness of guilt there. But let's just hold on for a minute until we get there. We got, can the defense attorneys, this is Idiot Wind, can the defense attorney explicitly ask that she provide fuller reasoning on decisions she renders where there is lack to develop the record? Thoughts on why we haven't been seeing that? Love you both.
Well, so I have a couple thoughts about this. They can, but they're not guaranteed to get anything from her. She's not really obligated to say anything specific in her rulings. But part of the reason why they're not is because generally it's not to their advantage to encourage her to make a better record of her reasoning. When an issue goes up on appeal, for example, if there are facts that are necessary for her reasoning, such as, for example, with this ruling on Mr. Betterow. There are some underlying facts that are necessary for her decision that there is a conflict of interest here. What is that? The nature of the representation, the type of information that might be available, and so forth. You take all those facts out of the picture, and you don't have a conflict. You don't have a problem. So there's some kind of underlying factual basis there that justifies the ruling that she's trying to make. When a case like that, a decision like that, goes up on appeal, one of the things that gets reviewed is there sufficient evidence to justify her having made these factual determinations in the first place? And so this is a very good example where this seems to be pulled out of the blue. We don't really have much of a record in this case of the relationship between Karen and Turtle Boy, of what is going on with the respective prosecutions, what type of information you might expect to be available from both cases, what types of restrictions are in place on that information. She seems to be maybe either inferring this, or she's relying on information that is extrajudicial, that's not part of the record before the court here. So it's to the advantage of the defense to not have her flesh that out, because it just adds to the strength of their argument on appeal that she didn't have a basis to make this decision, because even the facts that she relied on, there's no evidence in the record for the court, the reviewing court, to be able to look at it and say, well, did she make a correct factual determination or not?
Yeah, exactly. And, you have to develop the record, and you have to know exactly what the conflict governs, and exactly what Judge Everett did. You have an in-camera hearing where nobody gets to see it, and they talk about the conflict, talk about the facts, and talk about everything, and explain the ruling. So yeah, well, like you said, I think strategically the defense should not, bring it up, because this is just stronger for their appeal. All right, let's move on here. We got Lolo the Good Dog. The concern is focused on TB and KR defense attorneys sharing protected info, but is the prosecution for both these cases restricted as well? Well,
that's such a great point. Such a great point, because the Norfolk County District Attorney's Office is in the same position as the defense is, in that they have attorneys in their office that are prosecuting Turtle Boy with access to that information, and attorneys in their office that are prosecuting Karen Reed with access to that information. Are we to just take it on faith that they have instituted a hard wall between these lawyers? Yeah, there's nothing in the record that tells us that anybody has required that at all.
Exactly. Lucy Ferrer, and I'm saying her name wrong probably, got to send love for anyone who collabs with Andrea. Andrea, yes. This is our first time, by the way, but I'm sure it's going to be the first of many.
I hope so. This is fun.
Yeah, Baba Lessi's linguistic prowess. From a federal appeal level, isn't it one of the venues that helps to decide future precedent and law? You want to take that?
The federal appellate courts are very much a policy oriented type of court. Where we're at with habeas is it's a little bit of a kind of murky middle ground, because habeas in and of itself is kind of a review process here. They're looking back at what the Massachusetts Supreme Court did, and essentially is it correct? Does it impede on some of Karen's constitutional rights? So they're exercising independent legal judgment to evaluate that under federal constitutional standards. It's a little bit of a murky area, because at the district court level, when they're considering habeas, they aren't typically considering the bigger picture policy types of issues. Those things come up when you get up into the appellate realms. And so with that, those would be issues like, for example, one of the points that I've made on my channel that concerns me about this double jeopardy jurisprudence is the way that it seems to allocate so much power to the state and to state legislatures to define what a verdict is. And that then is going to, if we just defer to that in state courts, whether or not there's a verdict, then that means the state courts have a massive amount of discretion to determine the scope of somebody's right to a jury trial under the Sixth Amendment. And that just seems to me to be kind of wrong as a matter of policy. Typically, constitutional rights are something that need to be delineated as a matter of constitutional law, not as a matter of, the state passed this rule or passed this other rule. There's nothing under this framework that would prohibit a state from defining what a verdict is in such very specific terms that, for example, maybe many acquittals wouldn't even count as a verdict under this law. And so does that mean, that the state would have the power to essentially be able to legislate away not guilty verdicts? I'm using an extreme example, but just for purposes of illustration, that under this framework that we're working with, that would theoretically be permissible. So that's the kind of policy issue that it's unlikely to come up at a federal district court type of level, because they're just going to be looking at what is the law and what is the framework that we have to operate under, and did the Massachusetts Supreme Court satisfy that framework? But if this were to go up to a higher level, the Seventh Circuit are we in over here? Or even theoretically the U.S. Supreme Court, although of course that's unlikely. Right. Those are courts where they tend to be far more concerned about the policy types of implications, because their decisions are precedential in a way that the district court's decisions are not. So their decisions are going to affect all cases that come down in that circuit. They have to be thinking about the bigger picture and not just the specifics of Karen Reed's case.
Yeah, 100%. Let's move on here. We got Jay Beans starting late. One thing that's so infuriating is that the Commonwealth specifically stated odontology was junk science. And remember, we all remember when
right.
Valley, yeah, they are right. I mean, that was a good point, which is completely fine, if odontology is junk science. But now you got this expert who's not an odontologist, forensic odontologist, and he's going to talk about that he took molds from Chloe's mouth, which purported to be Chloe, and now he's going to compare them. That's exactly the study of one. Yeah, exactly. All right, let's move on. We've got Flummox Celeste. I think that if Karen Reed was not a white, wealthy woman, she'd be sitting in jail because lack of means/public interest to fight the corruption. That's a good point.
Yeah.
We've got Ellen Victoria Lesson. No, love this conversation so much. What do you two think of the juror dismissal issue? Why was Fanning the NE reporting the rumor? Why no hearing? So, yeah, I mean, I was thinking that when I saw that motion to dismiss, and I was, talking about the jury issue, which is, again, the whole reason why you have an evidentiary hearing is because you don't have all the evidence. You have enough. There's something substantial enough that there's a concern here. You've heard enough, and now you need to have an evidentiary hearing. When the argument is, well, haven't shown any evidence of this. Well, that's what an evidentiary hearing is for. Like, we showed enough to get our foot in the door, and now let's call these people and see what's going on. Now, this was the first time that I heard about the fact that how this actually came about. That you have some unidentified, unnamed individual who apparently was spying on the jury, saw one juror who purportedly was acting inappropriately or having conversations that were inappropriate. He or she goes and reports this to Fanning. Fanning then goes and they knew to go to Fanning. Then the Fanning goes and reports it to a court officer. Court officer goes and reports it to the judge. They have a sidebar. And then the only action that's taken is that the juror is called, asked about it. Seems, according to Alan Jackson, that she denied it. And she gets thrown off the case anyway with no other evidence or investigation into that issue, which is, I think that's reasonable enough to have a request for an evidentiary hearing to flesh out all these issues.
100%. This is a major issue. This is another one of those potential appeal problems that they can just hold in their back pocket. Because if you're going to remove a juror who's been properly seated in a case, has been qualified, you have to have a showing of good cause. And once again, there has to be a factual basis to be able to justify that conclusion. There's no evidence before the judge other than the jury denying that any of this happened. And so she has nothing that is a matter of record that she could rely on to say that any type of misconduct or something disqualifying took place. So I think this is a major problem that is likely to come circle back around if we end up in a situation where Karen's convicted and she has to appeal. because it implicates double jeopardy. Once again, she's entitled to the jury that she picked the first time around. And so if a juror is improperly removed, then she was denied that right.
Yeah, 100%. Melissa Dotson, gift 5 brother council memberships. Thank you for that. Tara Eised, I'm hoping the feds are waiting till after the second trial / misjustice is over to let all bad actors bury themselves deeper. So I guess this comes back to one of the questions which probably people want to discuss also, is whether you actually believe that the federal investigation is over.
Mm-hmm.
So
I'm skeptical. I'm skeptical. I don't have a position on it one way or another, of course, because I don't know. I'm not involved. But under the circumstances where the only people who are subject to this communication are the people who are believed to be the targets of this investigation, that seems to me to be pretty suspicious. If the federal government wanted to communicate that this investigation is over, they have the means to be able to do that themselves using these conflicted appearing mouthpieces. Just seems to me to be that it just seems a little bit infeasible. The point that I also made to folks on my channel: long-standing tradition in law enforcement investigations, they are allowed to lie. They are allowed to lie and to mislead the subjects of their investigative efforts. And so, it's certainly possible that this communication was given and that it isn't true, that it's done for the purpose of creating a mindset, seeing what happens when the folks have the belief that the facts are this way. So I see certainly avenues where this would not be a truthful recounting of the situation. I don't know one way or the other, but just based on what we know right now, I'm skeptical of it.
Mm-hmm. Until you see a formal announcement by the federal government, you're not going to put all your eggs in that everything that was said in court is actually accurate.
I'm not going to take on faith that these witnesses who have so many credibility problems already in this department, I'm not going to take their word on faith. That's just where we're at.
I got you. Okay, I can't see Flemex LSC. I can't wait to see KR's 12 experts. Yeah, it seems like they just filed a notice with 12 different experts. And then I think there was a motion for that the Commonwealth filed for more time to respond because they have to go through these 12 experts. Yeah, I wonder who these new 12 experts are also. Wonder who else they're going to call. Gravel Gooder, new member, thank you for that. Let's see what we got here. Zeldabad, does the judge saying I'll allow it instead of overruled affect the record in any way? Not in my opinion. What do you think?
No, the effect of the ruling is clear.
Right. Okay, we got GA. Hello, Kitty. Can the defense call out to the judge when Hinkie speaks without filing written motions or affidavits? Why does he have a license to speak freely? Well, I do find this. You'll file something in your papers, and then you want to add something to your argument. I've had judges ask me, especially when there's a response, do you have anything to say back to the response, or do you want to add anything? So you do find it, and it is something that the defense keeps pointing out. I think that if it's something that's really material and that can really affect the judge's opinion, I would ask, Your Honor, I need some more time to brief this issue. They're bringing it up for the first time now. If it's just another kind of response to some of the arguments that I've made, okay, that's what happens in court every day. But yeah, I mean, like if this is like the bombshell moment or whatever, and then, where's your attachments? Where's your affidavits? Where's your evidence of this? And where's the case law supporting what, like that type of thing? That's where I would take more issue. And they have been definitely saying their piece about it. You agree with that?
Yeah, I think best case scenario, it just shows very sloppy preparation by the Commonwealth to not be making that factual record of what they're asserting. It is a situation, I think, like you're saying, there might be reasons why the defense would want to sit on it, because if they get in the habit of doing this in situations where it isn't necessarily that material or that important, you can go ahead and wait to drop the hammer on the situation where it is very significant. Maybe it is a big misrepresentation. Maybe it is something that the defense knows they'll be able to prove that this can't be substantiated. So we kind of saw a little hint of that with David Yannetti responding to that representation that that Mr. Brennan had made in court about extrajudicial statements that he made on court TV. He knew very clearly that that was in the course of a court hearing. Mr. Brennan doubled down on it, and where did it get us? It got to a situation where Mr. Brennan has to go on the record and mea culpa and acknowledge that that was something he got incorrect. So you just pick your battles on those ones a lot of times for strategic reasons, and when you can throw it back at them, I fully suspect that they will take the opportunity to do that.
Yeah. Okay. Moving on. Letteros by Bettero. What's your opinion on the way the judge handled the Fanning issue? Seems to me she was worried. Why would she not insist on proof of the juror misconduct? Yeah, we spoke about that. I think we both think it's a little odd the way that she handled that. Kelly Reed, thank you both for your legal analysis. If either of you were hired by the defense, which witness would you most want to cross-examine?
I'll let you go first.
I would have to say Proctor. I mean, I think Proctor is just any attorney salivates when you got those text messages and his conduct on this case. I mean, that would be, you'd have so much fun preparing that cross-examination. Probably people are going to say Jennifer McCabe also, but I think that that's a good one. And also now we have a great moment, a great gotcha moment with Higgins when he's on the phone, apparently, when he denied that. That's going to be fun. So what do you say?
For me, it's definitely going to be Jen McCabe. She is just a wealth of contradictions and changes and inconsistencies. And so my skill when I was doing trial work was always in the kind of preparation and the detail focus. That's what I would do. I would have a big binder that's full of all the reports and all of the statements and all of the inconsistencies, because that's your ammunition when you're cross-examining a witness. She's given them so much to work with, and all they have to do is point them out and be systematic about it. It's not a situation where you have to be mean or you have to be challenging. You can be very matter of fact, and it's just the opportunity to potentially have a lot of fun with what this witness has already provided. So easy answer for me, Jen McCabe.
Okay. Okay, so we'd be a good team. I'll do Proctor, you do Jennifer McCabe.
Done.
We got TCP, very ignorant with regards to the dates, but couldn't the video of Higgins on the phone outside the PD have been used to get the order for his phone record and thus prejudicial? Not sure what the question is really asking, but from what I've seen in the filings, and this is something interesting that I found also, is that Alan Jackson and the defense in their motion said very clearly that he's on the phone. In the response, Hank Brennan never acknowledges that. He just says he was in and about the Canton Police Department at around 1:30 in the morning. He doesn't recognize or acknowledge that he was on the phone. But that seems to be the date. That seems to be the time. I'm not sure if that's how they're able to get his phone. They probably go ahead.
Yeah, well, I think yes, in general, had they had this information, it would have supported their request to be able to get his phone and to check those records. I think the problem
before he destroyed it.
Yeah, he had already destroyed it. He destroyed it before the preservation order could be made final. So
right.
It wouldn't have helped them from a practical standpoint.
Well, it was nice of him to decide on his own what was important in this case, so that he made sure to get that downloaded, turn over those text messages between him and Karen Reed, right?
But it does potentially open the door, I would think, for them to be able to get his phone records, even though you can't get the phone itself. The records of the calls and communications are something that you can obtain from the carrier. So are they going to do that? I don't know. We'll see.
Yeah, absolutely they should. Flemex, let's see if she's convicted in trial 2. Can they bring up problems in both trials on appeal?
So some they can, most they cannot. Things that typically go to trial errors, like they admitted certain testimony that they shouldn't have, or rulings on objections in the first trial. Those are potentially not going to be something that you can raise in an appeal about the second trial, because they're moot. The remedy for those errors is a new trial. She's already getting that anyway. So it's not something that the court can really provide additional relief for her for. However, errors in that initial trial that either go to her double jeopardy interests, such as this issue with removing the seated juror, potentially without an adequate basis to be able to do that. Those types of errors would survive that first appeal because they implicate her right to not have to go through a second trial in the first place.
Yeah, amazing. Kristen from Manhattan, $50. Thank you for that. Martin and Andrea, intellectual legal powerhouse. I got to agree with that. I love this collaboration for the both of you. What is one argument, expert opinion, or position that has not been raised, which you think would be most impactful? Thank you for all that you do. That has not been raised yet. I mean, they already talked about the dog bites. You got a dog bite expert. You got the ARCA experts. Not sure. Maybe an expert showing that when 10 people leave a house, they're going to notice a 6'2", 200 whatever pound man lying in the front yard. There's been some suggestions that it's science that when 10 people are walking out of the house, they won't notice it. So maybe if you get some experts there saying that out of 10 people, someone's going to notice it, then maybe that one might help.
For me, I think it's going to be the tail light. I think it's going to be really, really digging into this issue with the tail light, the reconstruction, the condition it was in, the way that it appears on all these different videos, the material that the tail light is made from, the force that it takes to break the tail light. What would the tail light appear on a dark camera situation if it's in different conditions? If this is indeed a frame job, then that's the weak point, the point where they had to create the evidence to make it look like Karen Read was guilty. And so that's the thread that the defense can pull on to try to unravel the frame up and show how it was done. So that's probably for me where I would focus on. The one thing that I think we haven't seen an awful lot of, exactly what pieces went into that reconstructed taillight. Were there additional pieces beyond, that they found beyond what was ultimately fitted back in? Who found what pieces? I did see somebody had gone in and traced through the testimony which pieces are attributable to which police officer. And it's not a random distribution like you would expect it to be if this taillight just shattered and ended up in the street and people are kind of randomly finding plate pieces as the snow melted. No, it was this officer found this chunk. This other officer found this chunk. Let's get a statistical analysis of that, for example, the likelihood that would happen. And then the whole piece that's missing, even when the taillight had been reconstructed, the odds that if you didn't recover, some pieces of the shattered taillight, that it's going to be all in this particular area. That's where I think the frame up can be strengthened and can be substantiated. So that's what I'd focus on.
Oh, that's very interesting. That's a great point. ABC's docket 199. Love you guys together. Please keep pairing up. Okay, well, if that's what the people want, that's what the people are going to get, as long as Andrea's okay with that. Jonathan Dean, did the girl get dismissed during Colleen Crawford's testimony? She has a business relationship with Trooper Fanning.
I'm not sure who the girl is.
Not sure either. Let's move on. Mama Carter, how does Hank get away with never putting what he's going to spout in the papers? I've never seen a prosecutor practice this way. Okay, we kind of spoke about that. Hank's hashtag not skin tag. What legal and ethical consequences could Hank face if it is proven that he knowingly presented false statements during the trial proceedings, given he's faced none during pretrial?
Well, knowingly presenting false statements in a trial, this is a NAPUI problem. That's another U.S. Supreme Court case that talks about, as a matter of due process, the prosecution may not knowingly elicit false testimony. And so it's come up in a few circumstances. There was a case that just came down during the last docket, the Glossip decision, where a death penalty conviction had been reversed due to this NAPUI error. And so, yeah, I mean, in terms of Karen Read, it certainly helpful from an appellate standpoint if she can demonstrate that something like that happened. But what sorts of consequences do prosecutors actually face as a result of misconduct? Well, unfortunately, you can kind of count on one hand the times when prosecutors who have engaged in misconduct have actually suffered any kind of consequence for it. We can identify Mike Nifong in the Duke Lacrosse case, where he withheld the exculpatory DNA testing. And we have the guy whose name I can't remember now off the top of my head, but he was down in Texas. He had subsequently become a judge. He was basically outed as another prosecutor who had withheld exculpatory evidence, resulted in conviction being reversed. He was prosecuted and I think got 1 day in jail as a result of it. Most of the time, the prosecutor doesn't even get named. So what's the consequences? They go on to have a successful career and advancement and maybe political advantages because they won the case, and to even have them named in an appellate opinion that reverses a conviction that they got due to misconduct is kind of exceptional. Rarely happens.
Right. So basically, your answer is that they become a judge. That's basically if that's what happens,
or a senator.
Right. But yeah, in a perfect world, then obviously they would face some severe ramifications aside from the case getting dismissed. But they would also face other, professional responsibility problems. Okay, let's move on. Lola the good dog. I thought it was telling that judge did not clarify Fanning's commander job responsibilities, only that he was not in charge of the jury. So, yeah, that did come out eventually. But she just wanted to right away say that how can you file this with a good faith when you know that he was not in charge of the jury? So, but Alan Jackson kind of clarified everything there. Stephanie Coco, renew trial focus. What about the witness who let it slip? John was inside the house and steers steps on phone.
Yeah, I'm trying to remember who that was. If that was
somebody said that they may have seen somebody come into the house. Was it one of the females that said that?
It was. Yeah, that when they weren't in the house at the same time or something, like Colin wasn't in the house when John was in the house or something like that. It was one of those types of comments. Yeah, you just have that comment in your toolkit so that when that witness is testifying, you get to confront them with that. It's something that they've given you. It's a piece of evidence, a weapon that you have to work with. So hopefully they're able to do that.
Yeah, and obviously the phone registering steps is a critical piece of evidence in this case, which, again, I think just common sense really tells you that there's no way to manipulate these phones. They spend how many millions of dollars on this technology, and then you're just going to be able to easily manipulate it by pretending you're going up and down steps. It just goes so much against common sense. I think this
is definitely an area that's ripe for expert testimony. So it wouldn't surprise me at all if one of the 12 Good experts is one of these people. But also, you do have to wonder, don't you, how many times the Commonwealth has relied exactly on this type of information to convict 100%. People, has gone 100%. In and argued to the jury how reliable and credible it is in order to get convictions. I'd love to see it if somebody had the opportunity to go in and maybe review the last, 3-4 years of the Commonwealth's prosecutions and identify those cases and be able to present that.
Yeah, based on Celebrate, how many people are sitting in jail because of Celebrate? And now Celebrate's in this case is all of a sudden, unreliable. Zeselex, in the first trial, they were able to prove that there were false memories spread, especially in the EMTs. Do you think that's important to focus on?
Oh, I definitely think if the EMTs are going to get on the stand now and testify that Karen said, I hit him, they need to be able to undermine that. And they can do that by showing, like they did in the first trial, none of this was in the initial reports. None of this was reported to the hospital. It wasn't in the places where you would expect it to be. And not only that, nobody behaved in the way you would expect them to behave if somebody is there at the scene making self-incriminating statements. There would have been, more of an effort to substantiate that. Maybe we would have immediately gone and documented the state of her car. Maybe we would have interviewed her right off the bat instead of letting her leave the scene. So it's absolutely going to be a focus. Yeah.
The fact that does not appear in any report, in the EMT's report or any sort of records, that's really, to me, it's a problem. I mean, if it didn't, I mean, ask any medical professional out there. If it's not in the records, it didn't happen, right? So, I mean, that's how they're trained. So I think that's a big problem with that also. Bobby Alessi's linguistic prowess again. If Dr. Crosby is only being allowed in as a rebuttal witness, will the defense have the opportunity to rebut his testimony?
I mean, rebuttal will likely be in the discretion of the judge. What I would expect the defense is going to do is they'll just pre-butt it. When they have Dr. Russell on the stand, she will have already had access to Dr. Crosby's report. She knows what his criticisms are going to be and what his basis is. She's going to have the opportunity to explain why it's a bunch of junk before he ever gets on the stand and tries to present.
Exactly.
So that's I'd expect that to go down.
Yeah, I definitely expect that happening also. Kristen from Manhattan. First of all, thank you, Melanie Gore. Also, Kristen from Manhattan, hit the like button if you want to see a collaboration with Martin and Andrea again. Agree with that.
By the way, I just spent on the name issue. I just spent 2 months in South America where I was Andrea the entire time I was there. That is the Latino pronunciation. Even in my own family, I get different variations. So honestly, I'm fine with however it comes out of your mouth.
Okay. Now I think it's already, I can't even say Andrea anymore. Now my cousin's wife's going to get mad at me. Okay. Well, now the crash daddies are free to use and hire. Do you think the defense will ask them to do any further testing? I don't think they're going to be asked to do any further testing because that's going to, maybe take away some of their credibility. You want to keep them as much independent as possible. They already wrote everything that you really need in the report. Maybe to hire a new expert to do something, okay, but you don't want the ARCA experts' credibility touched at this point. And they're already going to focus on the fact that they paid them $23,000 and all that good stuff. You don't want the jury to be confused. Wait, what were they hired to do by the side? Did they hire them after? You don't want that touched. So that would be my opinion. I think you agree with me.
Yeah, 100% agree with you on that. And I think, incidentally, the whole Commonwealth trying to impeach their independence with the $23,000 payment, I really think this is a be careful what you wish for type of situation, because I don't know how that doesn't open the door to explain fully. Here's the context. Here's what they were actually paid for. Here's what they actually did. Here's who paid for that. Here's the context. The jury is going to learn that there was this independent investigation by somebody and that there was a previous trial where the prosecution failed to prove beyond a reasonable doubt that Karen committed the crime that they're accusing her of. So I don't know that that's something. I just don't know that that's a door they want to open.
Yeah, we're gonna have to see how Judge Cannone deals with that because exactly bringing up that information. So then, what exactly is the defense going to be able to argue? Also, I mean that's a great point. That's going to be a dilemma. How's she going to deal with that? All right, proctored and doctored. I think they need to show the force it takes to break polycarbonate, and also that the same force would have had to break the bones in his arm, not just abrasions. Yeah, I think you spoke about that. That would be one of your focuses if you need one of these 12 experts to testify about. Mm-hmm. We got Diane in Karen's case. Why is the DA using a special prosecutor, not an employee of his office? I think because they just don't have anybody as good as Hank Brennan. A lot of times I feel like, the prosecution in the DA's office is usually you get everything, in a bow, and it doesn't take that much skill to be able to prosecute a case. That's why most of the time they get convictions. When you get a case that's a little bit novel, a little bit more moving parts, it takes a little more skill, a little more trial skill. That's why I think they start to feel like, we need someone who's used to this type of thing, which is usually defense attorneys. And that's why they go out and hire a special prosecutor. What do you think?
Well, I mean, this is the $1 million question, right? We'd love to know. I don't have a particularly high opinion of Mr. Brennan from what I've seen so far. I think he certainly has a different skill set than Mr. Lally did, but I'm not necessarily convinced he's going to be more persuasive an advocate for the Commonwealth than Mr. Lally was. One of the considerations I've given is just the possibility that the Norfolk County District Attorney's Office wants to distance themselves from this prosecution and kind of create this impression of independence that it's not really their decision. And that's because of all the moving pieces that have been circling with the federal investigation, with the prosecution of Matthew Farwell now for the death of Sandra Birchmore, that the Commonwealth has declined to pursue that. There's just some issues there that I think could maybe, if the jury had the opportunity to learn about them, raise questions about their independence and why they are in fact making the decisions that they're making. And that all tends to play in favor of the defense's argument that this is a corrupt office and a corrupt system here. And that's played out in the framing of Karen Read. So just to try to distance themselves from the possibility that type of argument could be raised.
Even though they're paying him more than they'd be paying Lally.
Oh,
a lot more.
Yeah.
Alessi's big brain to free Karen Read, 2 best looking and clever lawyers on YouTube. Thanks, guys. Thank you. Joss Girl, Andrea. I'm sorry. I said I'm not going to do it, and I did. Okay, I know you don't mind. Andrea, your point on the blood coming down his shirt.
Mm-hmm.
If he was hit by a car and landed on the floor, how did that happen? I guess you made some sort of point about that.
This came up during the very first trial when we were watching this. I boxed for about 10 years. And so I've had a lot of bloody noses. I've gotten in fights and I've it's happened, like comes down your shirt and stuff. And so as soon that's really what I was waiting for, because I came into the first trial pretty much a blank slate. I knew very, very little about the evidence, the allegations and so forth. And so my bottom line is, look, the foundational fact here is that you need to prove to me that John O'Keefe was hit by a car. So what's the evidence going to be that's going to show me that? And as soon as we got into the forensic witnesses who are showing us his clothing and the pattern of the blood, I'm like, no, like it just, I'm done. Like this is a fight. It dripped down the front of his shirt onto the front of his pants and onto his shoes. That's what happens when you get in a fight. And I just don't see a way to reconcile this with a theory that he was knocked unconscious into either a prone or a supine position, just because of gravity. How on earth is gravity bringing this down his front all the way onto his shoes? Even if we had a theory of like, well, there was some blood in the witnesses when they arrived at the scene at 8 a.m. and they're moving him around, maybe the blood dripped down at that point. How did it get on the top of his shoe? How did it get on the toe of his shoe? Now, I'm sorry, this is a fight. So
very interesting. Maybe that's another expert.
The expert witness could flesh that in as well. A blood pattern expert or something like that.
There you go. Yeah, blood pattern or blood spatter analysis. Valerie Michelle, this has been by far one of the most, I think the most, but okay, I'm going to let that go. One of the most informative and best slides I've seen in a long time. Please keep doing them. You two explain things so well. Thank you for that. Veronique, I would focus on the fact that no picture of light was taken and statistics related to all the camera issues. 34 Fairview, library, PD, etc. That those cameras are going to play large. Letters by Betterow, in my opinion, Officer John O'Keefe's body and clothing, along with Dr. Stonebridge's testimony, tells us everything we need to know about what happened to John O'Keefe. How is blood flowing downward? If he was hit and fell, he was beaten. In my opinion, that's exactly what Andrea said. Tara eyes, at some point you can all go through a timeline of the factual bullshit in this case. That'll take a little while. And then finally, before we move on, Southern Mom, it seems unfair that KR's team has to turn over witness impeachment material. Is that normal? I love the collab with you all. Free Karen Read. So I spoke about this on my channel, which seems to be an oddity in Massachusetts, which for some reason, I mean, this was news to me, but generally speaking, the way it works is you turn over information on your witnesses and they turn over information on their witnesses. You don't find that much that, I mean, not that I'm aware, but this is apparently Massachusetts. If you get an order in Massachusetts, you could require the other side to turn over impeachment material on your witnesses to completely prepare them for any lines of cross-examination that they're going to face. So this is something that was ordered in this case. And this is what they have to do. This is why they turned over that information on Jennifer McCabe, which is why they had that meeting. And then that report by Lieutenant Tully. By the way, this is one of the things I brought up on my channel. I'm not sure if you caught this. Maybe you did. Probably did. But the fact that when they turned over this impeachment information from Jennifer McCabe, that her phone was registered at Sergeant Lang's house. And then she never told that to anybody because it was an oops, I forgot moment. And then they were presented with this before her testifying. Obviously, they got together, figured out a story, and then Tully wrote a report about it 19 days later, and then turned it over like another couple of days later. So that was like, like, hey, I mean, I thought that could have been argued in the motion to dismiss by Alan Jackson. He left it alone. He kind of just argued the Sallyport videos. But I think that's also, that shows misconduct. That shows why you waiting in the middle of a trial. A new witness gives you more information that you never knew before. Why don't you immediately write that report? It wasn't like a lengthy report. It was like 3 bulletin points of the report, and he turns it over only 19 days or even later. He authors it 19 days later, but then he turns it over like a couple of days later. I think that's an issue, but that's what Massachusetts law allows, at least in terms of the turning over the impeachment information. But I think that smells also a little bit misconduct should be explored there. What do you think?
Yeah, I think that's a great point. It's certainly out of the norm of my practice. My jurisdiction, you have to disclose your case in chief, and that's pretty much it. It really defeats the purpose of impeachment to give the witness a preview of what they're going to have to explain. It takes the sting out of your ability to really confront them. I did kind of start thinking along lines of, is this an impairment of the right to confront witnesses, being compelled to put them in a position where now you can't adequately confront them because they have the opportunity, like you said, to kind of come up with a cover story. I suppose that the answer to that is that, well, your remedy is through cross-examination. If they tailor their testimony, show the jury that they tailored their testimony. So that's kind of what I expect is going to happen this time around. They're going to focus on that timeline of events and how that was something that newly emerged only after they became aware that they were going to be able to put her at a place where she very much did not want to be able to be placed.
Yeah, and there's some cases that Yannetti, I think, was quoted to where it talks about how it really takes a lot of the point of cross-examination out when the other side knows exactly what's coming. Again, you're looking for the truth, but so which way is the best way to get to there? Let me ask you, I know it's been a little while. Are you willing to continue a little bit further with the marathon? Because we do have some other issues that I'd like to discuss. We got through most of the comments or questions. So do you mind?
Yeah, absolutely. I got some more time.
All right, great. So let's pull up the this motion to get the Turtle Boy text messages, or the text messages between the intermediary. You see here that they do quote to some cases here. So I mean, some text messages here. So let me just read this for you, just kind of get you oriented. As demonstrated by the search warrants generated as part of the special prosecutor's investigation, the Commonwealth alleges that beginning on around April 17, 2023, the defendant took deliberate action to start sharing defense theories, privilege materials, and evidence with Mr. Carney, even though Hank Brennan calls him Kearney, and I was guilty of that also in my last video, through an out-of-state intermediary. I mean, some of the things that he just says, I just automatically say, like, anytime I say methodology now, I just like I hear him in my head, and that's why I just end up saying it that way. So
nobody can say what if any anymore.
Oh no, that's like long. Yeah, that's old news. Okay. Evidence of Mr. Kearney did I say Kearney again? Carney, through an out-of-state intermediary. So there's some communications sharing with this out-of-state intermediary. The Commonwealth alleges that the defendant instructed the intermediary to communicate with her through the signal messaging application. By the way, nothing wrong with that, right? Explaining that it provides secure end-to-end encryption, instructed the intermediary to forward all information, which included witness information, home addresses, grand jury minutes, autopsy photographs, and generally every piece of evidence that the Commonwealth provided to defense counsel onto Mr. Carney. So they're alleging here that she had this conversation with this intermediary, and the intermediary would then give all this information to Turtle Boy. By the way, some people call him Dr. Turtle Boy. The Commonwealth, yes. I called him that once, so therefore it caused all the anti-free current readers to go crazy that I called him that. Anyway, the Commonwealth alleges to the defendant would put disclaimers or directives on certain pieces of evidence, such as denoting "do not share" or urgent, "do not publish anything from the report," and make it clear he, Mr. Carney, didn't just get it from us, but don't show the exhibits, just read them. Please tell him not to share the title. It has Yannetti's initials in it, DRY. So these are apparently what they're purporting to be conversations between Karen Reed and this intermediary. You notice that there's no exhibit here attached. So, but again, there's quotations, so they're quoting from somewhere. But then that was in April. And now beginning in the summer of 2023, they allege that now there's direct conversations between Mr. Carney and Karen Reed. Again, I don't see any exhibits here attached showing that there's been communications or full of call logs or text messages. And then they say there's also been some conversations, see number 12, between David Yannetti and Attorney Jackson. So therefore, from all of this, what they're asking for is to get all of these reports, all of these communications between Turtle Boy and this intermediary and Karen Reed. So what do you think? Is this a fishing expedition? What's your take on this?
Well, I mean, certainly it's a fishing expedition. Does it have some sort of validity underlying it? I can see a potential justification for wanting to get into these third-party communications to the extent that they might include prior inconsistent statements of Karen Reed or just statements that she's made about what's transpired, about her accusations as far as misconduct on the part of law enforcement and so forth. So I can see a potentially valid basis to get into at least some of that information. I don't see that what they have asserted here is really establishing their asserted justification, which is that this is showing witness intimidation. No, you've showed communication about the case. You haven't shown anything that suggested that Karen Reed encouraged or directed any type of action on the part of Dr. Turtleboy and his supporters. You haven't shown that even if Dr. Turtleboy and his supporters did engage in this type of activity, that it constitutes witness intimidation. Of course, that's an issue that's still pending in another court. When this came up in the first trial,
let me just stop for a second, because I think part of the issues that they're saying is that's why they said that she provided home addresses. I think that's probably why they're throwing that in, just to show communications like what you're saying. Yeah, she can communicate with 1 million people. It doesn't mean that you get all of her phone records. But now they made some sort of allegations that she told Turtleboy through this intermediary the specific addresses of these people. Again, I haven't seen anything attached to that evidencing that, but that's what they're claiming. So
to me, that in and of itself is not particularly nefarious. If I'm communicating with somebody who's in an investigative function, I'm going to tell them, here's where you can find the people that might talk to you, that might have information about what happened, that are going to be the people that I'm interested in getting them on record as far as what their story is and their version of events and so forth. So in and of itself, to me, that's not particularly nefarious. They really need to be able to draw a link between what is she intending the use of those addresses to be? Because it can also be something just as simple as, look, she provided him with wholesale discovery, and the information is in there, and she just didn't, she didn't go in and redact it, or maybe she missed it or something like that. We don't have any type of showing that there was some kind of nefarious intent in providing that type of information.
And what do you, go ahead.
No, go ahead.
No, so I was going to say, what do you think? I want you to finish the thought, because I want to ask you the follow-up, but go ahead. Just finish your thought, unless I just completely ruined
it. My thought process was, this did kind of collaterally come up in the first trial. They wanted to go into this in the first trial and to try to argue that what Turtleboy, was doing was witness intimidation, and that could be imputed to Karen Reed somehow was consciousness of guilt. And Judge Cannoni in the first trial basically decided this is too far afield. This is a collateral issue. It's going to get us into a trial within a trial situation, because we have to decide now who did what and what is the significance of it and so forth. And it's just not material enough to the issues about whether Karen Reed hit John O'Keefe with a car to justify going down that line. So I am interested in seeing, is this going to be a situation where her rationale just changes again, now that she has seen potentially behind the scenes a little bit, because she got all those off the record conversations that Karen and Alan Jackson had with Gretchen Voss? Has that colored her perspective on, maybe what is being done as far as the press strategy and the publicity strategy that Karen has followed in this case? So whether that rationale continues to hold, I think that's really the $1 million question that this motion brings up.
Yeah, and part of the reason why he's saying, Hank Brennan's arguing that he gets this information, is because it shows consciousness of guilt. You know, so like to kind of avoid that trial within the trial, like what you were saying, that's his ultimate in his conclusion. He asks that this can all be shown as consciousness of guilt, which obviously, you know, is admissible. And, you know, but again, the question is, you know, is this just because you have one text message about a home address to a journalist, investigative journalist, does that mean that now we get to discover all this information? And it really brings me to the second point about this, and that is that any time that there's been any request by Hank Brennan to get any sort of records, transcripts, off the record conversations, they've never objected to it because they've always postured that we have nothing to hide. We're not saying anything that you're going to find. You're not going to find anything anyway. You're not going to find smoking guns. So would this be a situation where they'll continue with that posture and say, you want all these records? We have no objection to them. You know, maybe Turtle Boy wants to hire his attorney to make an objection to this, like what happened with the Gretchen Voss and all those other interviews. They had their own attorneys get up and argue, and they took no position, Karen Reed. So do you feel like a similar situation, or do you feel like here we're going to see a little bit of a different posture by the defense, and maybe there are some text messages or communications that they don't want revealed for one reason or the next, whether it shows that she was involved there or not? But that's just question number one. And the question number two is that would you find that if Judge Cannoni does grant this, would you find that there's again another level of inconsistency here where the defense was asking for all the Sandra Birchmore reports and all the same investigating officers and their communications? Judge Cannoni shot that down and said, no, that's essentially a fishing expedition because that case has nothing to do with this case, even though there are definitely collateral issues there that can be, you know, that can be involved in this case. So she denied that. Is this going to be another instance of an inconsistency, or do you feel like the two are just so not comparable and that, you know, I'm crazy for thinking it?
Well, no, I think that's actually a very good point. And I'll just answer that part of your question first, because both of these issues go to the credibility of the witness. That's what the issue is. That's what justifies being able to raise this in a trial in the first place. The Commonwealth is essentially arguing that Karen Reed's assertion of innocence is not credible in light of these conversations that she's had and these actions that she's taken to basically publicize the circumstances of her case before the information comes out at trial. I think it's very similar, roughly equivalent to the same thing that the defense wants to do with the law enforcement witnesses who were involved in the investigation of Sandra Birchmore, and once again just managed to overlook 30-some thousand text messages, suspicious circumstances, all of that type of thing when it happened to be a law enforcement officer, one of the boys club who's under suspicion. And so it really substantiates that defense theory that if it's a cop, nothing's going to come down on him, just like Trooper Proctor said in that text message. So yeah, I do think it would be a little bit of a discrepancy in the reasoning there to allow the Commonwealth to go down this road and not allow Karen Reed to have a similar opportunity. As far as are they going to follow the defense the same strategy? I really don't know. I feel like in this situation, of course, I don't know what the text messages say. I don't know what the communications are. Maybe there's bad stuff in there. I don't know. Maybe there's communications about her thought processes and her theories and things like that might show the defense's hand a little bit more than has been shown so far, because Karen Reed hasn't testified. That's kind of always the ace in the hole that the defense has. They get to decide whether or not she's going to exercise her right to remain silent or whether she's going to exercise her right to testify. Do
you have any reason to believe that she's going to testify at the second trial?
I don't know. I've always been a little bit of an outlier in the criminal defense community, as far as I can tell, in that my preference has always been, whenever possible, I'm going to put my client on the stand. And the reason why is because even though the jury is going to be instructed, they have the right to remain silent, you can't infer anything against them and stuff. As a practical matter, and study after study of jurors' thought processes show, they can't put it out of their mind. They want to hear from the accused. They want to hear their story. And I think it's just a natural thought that people have that's very, very difficult for them to put aside. So I always want my client to testify if possible. I would not have found it a bad strategy at all for Karen to have testified in the first trial. Now, having said that, it's an advantage to her this time that she didn't, because she still has that element of they don't know what she's going to say. And so she can tell her story. The judge has, or the jury has, the opportunity to evaluate the credibility of it, and just her as a person. They sit there in the courtroom and they watch her for weeks on end, and they wonder, who is this person we're hearing so much about? Just being on the stand and communicating gives the jury a much better idea of who you are as a person. So it humanizes the defendant in a way that really very little else in a trial has the ability to do. So I don't know. They clearly had the strategy the first time around if they weren't going to call her. I don't know if that's going to change or not.
Okay, I didn't mean to cut you off with your other thought, but about whether Karen Reed's posture is going to be different in terms of, because up until now, anytime there's been any request for her reports, transcripts with off the record, with any journalist has been, go ahead, I have nothing to hide. And now here's a journalist, obviously a very different type of journalist, but that's going to be the question, what their posture is going to be. I wonder.
Well, I think it would be justified in this situation to have a different posture because of the very specific use that the Commonwealth wants to make of it. They didn't want Gretchen Voss's interview because they think Karen Reed is giving this interview in order to intimidate witnesses, right? In order to show some type of concerted joint effort to go out and get people not to testify or to change their testimony or something like that. So it's the inference that the Commonwealth wants to draw from this that I think is the reason why they would be more inclined to oppose it, even if there isn't a problem in these underlying records. Now, maybe, again, they just let it go and they let the Commonwealth make the case to the jury, and they make their own case that you can see for your own eyes what these communications are. And at no point in any of this is Karen trying to direct any type of action. She's clearly just trying to share information, get the public more aware of what the circumstances are in her case. So I don't know. I think so much depends on what the content of those messages are. But just the fact that we know the Commonwealth wants to use them to paint a specific picture without even knowing whether the content would justify that picture or not, that to me justifies being a little bit more cautious in this situation.
I got you. Okay, let me get to some more comments here. We've got Flummox Alessi again. Bev chastising the defense and ruling for not redacting impounded grand jury testimony and then turning around and putting grand jury testimony in her ruling unredacted. We got Forrest Dump. Also in limine, Dr. Russell is a pathologist. She wasn't allowed to opine on anything pathologically. Now should she be able to, right? I think she should be able to give an expert opinion about that. I think she showed the expertise for that. Again, I don't know. And also remember last trial, and I don't think this was clear from her order. And I think I said that they should clarify this. In the last trial, she was only allowed to testify that the injuries to John O'Keefe were consistent with the dog attack, and not that it was not consistent with an automobile accident. And I thought that it was not clear in the order this time around that she's going to be able to testify that. And I think that if I was the defense, I would want to clarify that with the judge. Is she allowed to say on the stand that this is not consistent with a pedestrian strike by an automobile? Yeah,
I think that's a good point. If it's within the realm of her practice as a forensic pathologist, she should be able to offer the opinion. And I could see how the context of the first trial, she came up late in the game. She didn't necessarily review, everything that's available in the universe to review. She's had a lot more time, and they've had a lot more time to sit down with her and go through a lot of these details and material and stuff. So it really is a different situation now that from my perspective warrants a second look.
Yeah. So I think that they should button that up. Here's an interesting question. Renee, if I'm saying that right, what type of juror would you pick for this case? Well, I'll tell you what I would not want on the case is anybody in law enforcement. But someone that I a lot of times they say don't have lawyers on the panel. I think in this case, from the lawyers that I've spoken to about this case, they all feel that that there's reasonable doubt here. So just as long as you're not a prosecutor, I would welcome a lawyer on this panel, on the jury, on the juror panel. Other than that, I guess it would be much more of seeing how they respond to my questions and things like that. But what do you say?
Yeah, well, this is something that I have talked about on my channel about picking juries and what the strategies are for that and so forth. And I'm 100% on board with you. And that last part that you said, you see how they respond to your questions and so forth. Selecting a jury is really about making a connection and your ability to communicate with certain people and to ascertain if they think about things the way that you do. I don't like to segment people. I tend to find it's not very helpful. I've told the story about the very first jury trial I ever did where I put a retired cop on the jury because we went through voir dire and I liked him. We were able to communicate very well. Everybody in my office thought I was absolutely nuts, that I had just thrown the case. He ended up being the foreperson of my jury and he delivered the acquittal. So it's just always it depends. There's certainly an argument to be made that if you get the right cop, you get the cop that went into law enforcement because they are ethical, because they are helpers, because they want to do the right thing. Those are the police officers that are going to be most outraged when you have at best such an extremely shoddy investigation, and at worst, all of these extremely suspicious circumstances that are potentially indicative of corruption. So I can see a situation where the right cop would be the perfect juror that you would want in this particular case. So I'm with you. I think it comes down to connection. One of the virtues of a juror that I have long extolled as a defense attorney, I want jurors who are open, who have that personality characteristic of openness. They're not going to reach snap judgments really quickly and then be hard to shake off of those, because the whole structure of the trial is you're going to hear from the Commonwealth before you ever hear from me. And so if you're going to be inclined to make up your mind really fast and then not move from that, I'm just at a structural disadvantage in being able to get a verdict from you. So I want people that are open. I want people that are skeptics. I want people who will consider different types of explanations, people who are not real fixed in their judgments. And that's the type of thing I'm going to be exploring through my voir dire process, is evaluating, do these jurors have these types of characteristics?
Yeah. And I always tell my audience, also, I tell my channel that jury selection is so critical. And unfortunately, we don't get to watch it in any of these cases. And that you can really start to win your case in jury selection. It's that important. And I've seen lawyers where I walk out of the room with my jaw open, because I can't believe how lackadaisical they are about it and how they're not taking it seriously enough. They ask a few questions, get some of the regular answers. Can you be fair and not prejudicial? And I'm just so surprised, because there's so much that's been written about it. There's really a lot of attention that I give to jury selection and how am I going to formulate my questions, what type of questions, how am I going to start planting the seeds already now in the jury selection so that I can already come back to that. Sometimes I reference what I've spoken about in jury selection, say, you guys all remember that I talked about that, you all agreed with me, and it's very powerful. So it's something that I wish we were able to see. I always find it interesting what type of questions other lawyers ask on jury selection, because we're always trying to think how to get, these questions, like you said, how do you determine if somebody's open? How do you determine how they lean one way or the other? One of the questions that I actually more recently have seen is, what type of bumper stickers do you have on your car? Have you heard that before?
I have heard that one before.
Yeah. So I've been hearing that a little bit more recently, what news channel do you listen to? And that kind of just gives them an idea about where this person falls. But it's such an interesting area, and it's unfortunate we can't see it and analyze it, because there's so much there.
Yeah.
Okay, let's move on. We've got Proctored and Dr. Turtle Boy said he was in a jury room and notebooks were just sitting on the windowsill. Can jurors ask to personally lock up their books so no one has access? Now, they're supposed to take care of it. The court officers, they're supposed to collect them and keep them safe. So I'm not sure what his experience was, but we assume everyone's following what they're supposed to be doing. Eric Clark, could defense will draw a timeline while questioning each witness, visual for the jury, then on closing, present the combination of all timelines? Sure, you can present the timeline and ask them to go through the timeline with you. I think so, yeah.
I think demonstrative exhibits are something that could potentially be very, very helpful for the defense in this case. It just is able to, some people are more visual people than others. And so to really be able to highlight, here's a demonstrative that shows all of the inconsistencies in this particular version of events. Here's a demonstrative that shows the improbabilities of all of these butt dials, just all of the weaknesses in the case. You can really draw attention to them in a way that can be much more powerful than just trying to verbally articulate that particular information. The $1 million question is going to be, is Judge Cannoni going to allow that? Because once again, judges have quite a bit of discretion when it comes to demonstrative exhibits and whether they would be allowed or not.
Yeah, that's true. And I think that's so powerful. It can't be understated. I felt, and again, I don't know what Judge Cannoni's rules were for closing arguments, but I personally, I always put together a slide, a PowerPoint, and I go through what I want to go through. I show them things. I point out certain things from like transcripts or pictures or evidence, whatever it is. And I walk them through and I show them slide by slide why I win. And I think it's incredibly powerful. And I would have liked to see that in Alan Jackson's closings. Although again, I don't know what his restraints were because of Judge Cannoni. So I can't fault him for that, but it's, especially when you have a complicated case like this, there's so many moving parts, so many witnesses, and you have only an hour to close. I mean, yeah, but it can't be understated, I think. Natalie's pitch, she thinks she's Linda Tripp. Okay. I'm not sure what that means. Do you know? Hubert, why didn't any of the first officers, detectives at the scene not see 47 pieces of red taillight and 2-3 inches of snow here? The other 20 came later. That's exactly a very big part of this case. Cranky, should the defense ask for the jury to be sequestered? All the criteria are there, but I don't think Bev would do it. Yeah.
Well, I think this question goes to, do you think that there is likely to be law enforcement interference with the jury or not? If we're suspecting a corrupt law enforcement presence and allegations that even in the prior trial that Lieutenant Fanning may have done something inappropriate, I think the question is, do you want the jury even more under the thumb and in the contact with these law enforcement witnesses than they would be if they can just go home at night, mind their own business, and so forth?
Yeah, that'll be interesting. Okay, let's go. We got Edward Kirkpatrick. Morrissey hostage email. Morrissey turbo case emailing judges ex parte about McAlbert's restraining orders. Huge ethic issues. Brennan now taint team himself. Morrissey emails. Why do we trust that?
I don't trust it. I don't trust it. And I have no idea why this is being allowed. It seems to me to be such an obvious conflict of interest. The person who is paying the bill of Hank Brennan is the subject of Hank Brennan's review. No, it seems to me to be clearly improper.
Okay, we got only a couple more and then we'll call it a day. Lola the Good Dog, is it possible to clarify / revise jury instructions during pre-trial? It seems rushed at the end and it's so important, especially with this case. Well, in my experience, we go through a lot of the jury instructions before, try to agree on everything. And then occasionally you'll still have some questions about certain jury instructions that you'll want in or whatever. So they'll do it at the end of trial also. But a lot of it is done, contemplated before trial. That's in my experience. What about you?
Yeah, that's normal. And we did see it in the first trial. They certainly had an instructions conference. I think the issue was that how that comes about. In my jurisdiction, the way it typically works is that the prosecutor prepares the set of proposed instructions that they want to use. Like Massachusetts, we have form instructions that, they're not required to use, but they're typically going to be the starting point for any type of trial. So the prosecutor will propose their form instructions. The defense will review them. If I take issue with them, I raise that. If I have additional ones I want to propose, I will raise that as well. So it's not a kind of surprise as far as what you expect when the jury instructions, the proposed ones, land on your desk. This situation in Massachusetts seems to be a little bit different because it's the judge who comes up with the set of instructions, not the parties. And I also noticed, as just in the course of of looking at some of the double jeopardy issues and the mistrial and stuff when all of this happened, her instructions did deviate from the form instructions, quite a number of times. Whether it's material or not is always kind of part of the question. But that's the thing that you really need time to be able to sit down. You need to be able to make that comparison. You need to think about, okay, she's saying it this way, the form says it this way. Is that something I need to be concerned about or not? We obviously had that issue in the first trial with the verdict slip for count number 2, one that had the lesser included offense instructions. And the jury did not have the opportunity to acquit on each of the primary and the sub ones. They only could convict of them. This
or leave
was
them blank.
Yeah, this was a big problem to me, and I think that the defense largely raised this issue as well, because it seems to be directing the jury to operate in a way that runs the risk of violating her right to due process, or her right to not be subject to double jeopardy. If they found her not guilty of the manslaughter charge, they found her not guilty of the next lesser included offense, but they could not decide on the last one, they should have the opportunity to be able to mark that on the verdict form to clearly indicate it, so she can't be retried on those charges that they had found her not guilty of. So that came out in the first trial. It was never really resolved. Judge Canoni had initially said, well, yeah, I see, and I'll take a look at it. But then when they brought it up later, she's like, well, I was really tired. I was, I needed to sleep or something. She just had an explanation for why she never went through and made the revision to that form. So they've had a lot of time now to sit with those instructions that were given the first time and evaluate them and see if there's any changes that they want to propose, problems that they have, be able to put their objections on record if they think there is something that needs to be different this time around. So hopefully the kind of rush to get the jury instructions done that we saw in the first trial is not going to be repeated this time.
Yeah, and something that I also do, I very often do this in trial, is where I'll walk the jury through the verdict form. Mm-hmm. And I'll show them exactly how I want them to fill it out. And that's why I thought that it was a little oversight by the defense that they only brought it up later after the jury was already deliberating. And that was something that I would definitely catch before. And if I had an issue with it, I would bring it up before I even do a closing argument, because I'm going to be going through the sheet. Or at least if they say in Massachusetts, this is how we do it, then I would tell the jury, look, in Massachusetts, if you find her not guilty, then you just leave a blank. Does everybody understand that? And even though they're not a respond, but I would make that very, very clear as I'm going through the verdict slip. Okay, we got the last comment here. Joss Girl, biggest takeaway from a defense perspective from the juror interview with Turtle Boy. My biggest takeaway, did you see that interview, by the way?
So this is on my to-do for this afternoon. Once we finish here, I have to finish listening to the interview. I have started it. I've had other things come up. I haven't had a chance to get through the whole thing. So I certainly have some thoughts about what I've heard so far, but I want to keep an open mind until I get everything that juror had to say.
Well, then guess what? I'm not going to say anything then. So that is going to be it for today. I mean, it's been over 2 hours, and I really very much appreciate joining Andrea, whatever I'm in the mood of. So thanks for joining us. We went through a lot. There's obviously some more to get to, but maybe we'll have to do another show, and I'm sure we're going to be seeing a lot of more motions and limines, hearings that we have to digest and talk about. So maybe we'll collaborate again. I think everybody enjoyed it, and I definitely enjoyed it. It's good to talk to another attorney who's actually experienced and watching all this stuff, and we can have an intelligent conversation. So thank you so much for coming on, and I'll just give you the last word.
Well, thank you so much for having me. It's been a real pleasure. One of the comments that I have made in the course of giving commentary on many occasions is that it's often unfortunate in the law that the bar for performance is quite low. As a legal practitioner, the sort of baseline is simply you look up what the law is. The law is not something we think up in our heads. The law is not what we think it should be. The law is written down somewhere in a resource that we can go and look at and find. And that's what we're really supposed to do. So it's always wonderful to find lawyers who appreciate that aspect of the legal practice, who are careful with their legal analysis, check the rules, and do the actual work that lawyers do when we're having opinions that we're offering about these types of cases. So you have the same approach to these cases as I do. I value that. I appreciate that. And one of these days we'll find something that we disagree on, and then that will be a very powerful discussion.
Yeah, that's right. I was looking for someone to disagree with me on either what the verdict should have been, or what I thought would have been a more interesting discussion was on the appeal. Why I felt Karen Reed should lose the appeal in the double jeopardy. Unfortunately, nobody took me up on that. So I'm sure we'll find at some point, and then we'll be able to fight it out like lawyers do, citing case law and statutes and laws and maybe other tactics that we use when we're trying to convince people of things. But yeah, it's been a pleasure. Thank you so much for joining me. And just hang on for 1 second as I end the stream. All right. Thanks, everybody, for joining. And hope this was enjoyable for everybody out there and educational. That's what I guess Andrea and I like to do, is not just talk about this, but we also like to research and make sure that we actually are coming from an informed place when we're talking about these issues. So that's something that I always like to stress on my channel. I look up the cases, the case law, look at the rules and then analyze them. And that's what lawyers are supposed to do. So I guess we're both doing what we're supposed to be doing, Andrea. So Andrea, all right, thanks a lot. And we'll see everybody here shortly at the next live.